In a landmark decision, a U.S. district court has stepped in to protect 133 international students. These students faced sudden termination of their SEVIS records, putting their legal status at risk. Without this ruling, they would have faced deportation. On Friday, the court issued a temporary restraining order, or TRO. This order requires the Department of Homeland Security to restore the students' SEVIS records, backdated to March 31, 2025. It also prevents any federal authority from misusing or sharing their personal information outside this case. The students, all F1 visa holders, raised urgent concerns about illegal actions from immigration authorities. This case stands out as one of the largest concerning SEVIS terminations. The affected students were actively enrolled in universities, many nearing graduation or participating in optional practical training. Charles Cuck, an immigration law expert representing the students, stated this situation reflects a disregard for immigration laws. He warned that damaging policies could drive top students away from pursuing education in the U.S. The students filed their lawsuit under pseudonyms, seeking protection from DHS and Immigration and Customs Enforcement. They received termination notices between April 1st and April 14th, claiming issues like criminal background checks and visa revocations. However, the students argued these claims were unfounded, noting they had no criminal records and complied with visa regulations. In their complaint, students pointed out violations of the Administrative Procedure Act and the Fifth Amendment. They insisted the terminations lacked proper notice and were arbitrary. Under F1 visas, they argued, they should be allowed to stay as long as they met academic requirements. Some students faced visa revocation, but this doesn't necessarily impact their lawful presence. They contended it was the CVS terminations that left them vulnerable to detention and deportation, causing irreversible harm. The court agreed, acknowledging the students showed a strong chance of winning their case. It emphasized that DHS's authority to terminate F1 status is heavily regulated and not applicable here. The judge pointed out that mere visa revocation does not justify SEVIS termination, emphasizing public interest in lawful agency operations. Judge Victoria Marie Calvert recognized the severe consequences these students faced. Potential loss of education, scholarships, and jobs led to significant emotional distress. Citing similar rulings, she affirmed the necessity of judicial oversight for SEVIS issues. The court dismissed claims that relief could be sought under the Privacy Act, clarifying it's not applicable to international students. This case reinforces the need for adherence to legal protocols, especially in immigration matters, ensuring fair treatment for all students in the U.S.